Welcome, everyone. We're letting everyone join for a minute as everyone signs in. Just a reminder to let you know if you want to ask questions, please put them in the Q&A and we'll get to them at the end of session and we'll get through as many as we can. Thank you and welcome. In the interest of time and knowing that we have a lot to cover, I think I'll get started. Welcome all. My name is Natasha Perez, and I am the VP of Communications for ACT, the Alliance for Climate Transition. As we know, these are very troubling times, whether you're an immigrant, a farmer, a or in our clean energy ecosystem. Between executive orders and shutdowns, many people don't know how to respond or what to do. That's why we're so excited to have the legal experts here today, Noah Shaw and Beth Neitzel from Foley Hoag, and Joe Curtatone, the president of ACT, who will share with us the impact and what's happening and some solutions for how to deal with it moving forward. So again, thank you all for attending. We will hold all questions till the end of the panel. You can submit your questions to the Q&A button on the bottom right hand of your screen, and we will get through as many questions at the end of the session as possible. Also, please direct questions to individuals if you have a specific question for them. If not, the question will be given to the group to tackle and answer. Thank you very much. I'd love to start with Noah. Why don't you tell us a little bit about yourself and what you do?
Great. Thank you, Natasha, and thank you to everybody for joining today. Noah Shaw, I'm a partner in the energy and climate practice here at Foley Hoag, based in the New York City office, as you can see behind me. Uh, we're here today because part of my practice relates to a pretty broad range of federal financial assistance recipients and how they are managing, well, first of all, they were managing their awards, and now they're managing the question of how their awards are going to be paid or not. I came to that after having been general counsel of the New York State Energy Research and Development Authority for 5 years and a senior advisor to the general counsel at the Department of Energy during the Obama administration. We have a pretty broad team of folks here at Foley, about 35 people working on energy and climate matters generally. And a lot of them right now are dealing with the issues that, unfortunately are leading the 6 o'clock news. Um, I think last count, we are representing double digits of financial aid recipients and whose awards total somewhere north of $3 billion. And those awards are across EPA, multiple programs at the EPA, the Department of Energy, the Department of Transportation, and other agencies, some of whom have had their funding frozen, some of whom have not. But it's not just energy and climate clients who the firm is working with. Beth and others across the firm are working with folks who are recipients of science research funding, people who are dealing with some of the executive actions that are emanating from HHS in the healthcare industry. So we are, fortunately or unfortunately, very much in the mix of this on a day-to-day, hour-to-hour, sometimes minute-by-minute basis, and trying to work with clients who include nonprofits, for-profits, and government entities on, what their situation might be and what their rights might be as they watch the scrum in the agencies and in the courts at this point. So with that, I'll turn it back to you, Natasha. I think I covered the general intro and what we're up to here at Foley on a broad basis. And yeah, so that's that.
Thank you. Beth, can you take a moment to introduce yourselves and tell us what you do at Foley?
Sure. Good morning, everyone. My name is Beth Meitzel. I am a partner in the litigation department at Foley out of the Boston office, although cross-listed in DC because my practice, which involves a lot of government-facing litigation and regulatory advising, frequently takes me to DC. I'm also, as the screen notes, co-chair of our appellate practice. My background is in Supreme Court and appellate litigation. I previously spent 5 years in the appellate practice of a large firm in DC and Boston. And before that, clerking on the Supreme Court, DC Circuit, and Fourth Circuit. So know well how those courts operate. Before joining Foley, I was senior counselor to the Secretary of Homeland Security, Secretary Mayorkas in the Biden administration. I worked with him at my prior law firm and joined him in that capacity and I was among many hats that I wore there, senior counselor for procurement. So I got to see sort of the inside peek at government contracting, and boy, did it look different. So now in this work that I'm doing with Noah and some other folks here at Foley, particularly in the energy domain, my piece of this, as you could imagine, given my background, is really to look at risk assessment for our clients. In other words, in the lead up to the inauguration, helping our clients understand the shenanigans that the Trump administration or congressional Republicans might try to engage in to rescind or freeze funding or to make their lives difficult with oversight work. Very quickly, sooner than I confessed that I had anticipated, we switched to helping our clients understand the implications of what was already transpiring with this funding freeze. And have been, of course, monitoring updates in the principal lawsuits filed by the states in particular, obviously the nonprofits case in DDC as well, but the states case at this point is farther ahead and really the bigger game in the IRA and IIJ space. So that's what we've been working on. As Noah mentioned, we're working with clients in some other areas as well, healthcare, and also education clients who are grappling with the impacts of the DEI orders, the gender affirming care orders and directives, et cetera.
Thank you, Beth. Joe, can you tell us a little bit about your background and how you approach this as a former government official and now the president of ACT? You're on mute.
Sure. Thank you. And sorry about that. Good morning, everyone. Thanks for joining us. My name is Joe Curtatoni. I've actually spent my career fighting for sustainable solutions that benefit our communities and economy. And if you don't know, before joining ACT as president, I served as mayor of Somerville, Massachusetts for 18 years and really leading one of the country's most ambitious local climate action efforts. And I've worked at the intersection of policy and economic development and climate innovation, and really working to ensure that clean energy isn't just an environmental priority, but an economic one. And now, as ACT president, myself and our team, we're committed to ensuring that the clean energy transition continues, that it's uninterrupted, ambitious, and it's inclusive. And really, that's why we're here today. So the clean energy economy depends, as we know, on stable funding. And without it, innovation stalls, workforce pipelines dry up, and critical infrastructure projects get delayed or, in some cases, even canceled. And as we know, this funding freeze is already creating uncertainty across the industry, discouraging private sector investment, putting clean energy jobs at risk, and threatening the deployment of technologies that we really need to fight the climate crisis. And unfortunately, we've seen this playbook before. The last time President Trump was in office, we saw similar efforts to dismantle climate funding, weaken regulatory protections, and slow down the transition to clean energy. But we also saw something else. We saw resistance, and that resistance worked. And despite the Trump administration's efforts, the clean energy economy continued to grow. Investments in renewable energy surged. States pushed forward with bold climate policies, and the private sector remained committed to sustainability. And really now we need that same level of coordination, that urgency and action. So beyond funding, though, we're also seeing another dangerous effort to undermine progress. And that's the attempt to roll back diversity, equity, and inclusion initiatives in the workforce. The administration, as we know, is pushing the false and really offensive narrative that hiring diverse talent somehow means sacrificing quality. And we know that nothing could be further from the truth. A diverse workforce strengthens our economy, it drives innovation, it accelerates the adoption of clean energy solutions. And we know, and when more communities are engaged in the transition happens faster. And that's not politics, it's economics, it's strategy. And it's really a fact that we all need to defend. And that's why we really have to push back against policies that weaken our ability to build an inclusive and effective workforce. The clean energy economy should be an engine of opportunity for all communities and not just a select few. So we cannot let the politics derail progress because the stakes are too high, as we know. And so this is the point we need to focus on. And I'd submit, here's some things we need to do. Amplify the voices of those directly impacted. Push and fight for legislative safeguards. Engage and participate in the legal system and legal efforts to fight these really atrocious policy reversals. And really build and strengthen coalitions across every sector. ACT will continue to work with our partners at Foley Hoag and other partners to provide updates and mobilize action, but we really need all of you, whether you're in advocacy, research, or industry, just step up and make your voices heard. Stakes are really high here, but we've been here before. We fought back then, and listen, we're going to fight back now. And we're not going to let political maneuvering stall clean energy innovation, and we will not let this administration slow the progress we made. And we're certainly not going to stand by while communities, workers, and businesses are left in limbo. Look, we know what's possible when we stand together. We've done it before, and we're going to do it again. But let's make sure the politics doesn't stand in the way of climate progress. Thanks, and back to you, Natasha.
Thank you, Joe. I'm going to go back to Noah and Beth for a minute. Noah, you sort of talked about your clients and the implications. So what exactly, how are companies, nonprofits, universities, how are people being impacted directly? And how are they tackling sort of this interim phase while they figure out what is going on?
It's a diverse set of reactions, I guess. As to echo Joe's note, this is uncertainty is obviously the enemy with respect to being able to make business decisions. And so what we see is a range of reactions. And then I can talk a little bit about some of the advice that we're giving. One, it really depends on the extent to which the sort of overall economics of the business are dependent upon federal funding. If, in some cases where an organization is either formed for the purpose of delivering a grant and a program, or where, the grant happens to take up a large portion of the pie of their budget, you're seeing frankly much more risk averse reactions, right? Because if that money gets turned off, the entire organization may go away. And so you're seeing a lot of decisions to pause spending, pause activities, not sign contracts, essentially not move forward with, the deliverables under the grant, which is not only problematic for the people who are affected and the delivery of the results and of the program, but frankly, just because this funding is paused doesn't mean that recipients don't have to live up to their obligations under the award, right? I mean, that sounds ridiculous, but the milestones and the requirements of progress and the reporting requirements, et cetera, all, as a matter of law, remain intact. So folks are having to make the decision whether to essentially spend money at risk in order to meet those milestones and deliverables or not, at which point they risk having their award terminated when they get to a milestone and they haven't been able to make sufficient progress because they're not getting money. So that decision-making process is a dynamic one and is really dependent upon, the risk tolerance and the overall economics of each organization, I'd say. Some organizations where, the award is a relatively small sliver of the overall sort of budget for activities, they're willing and able to sort of cover things while that particular funding stream may be, a little bit in limbo. I think, what has become clear, in addition to well, what's not clear, obviously, is what Beth is probably going to talk about more, which is what the heck is going on with these lawsuits, and what the scope of the restraining orders and all that actually is. But what is clear is that, what we are advising is that you can only control what you can control, and what you can control is the extent to which you are crossing T's and dotting I's and complying with the requirements of the award. My expectation is that to the extent, the administration is required to continue to live up to, their contractual obligations, they will be looking for ways to get out of these awards to the extent that the political appointees at the agencies don't see them as consistent with the executive order's policies as stated in Section 2, whatever that might mean. So it puts a premium on ensuring that flow down requirements and contracts are to the T, that everybody's got their conflict of interest policies up to date and implemented and policed in an effective way. That all of the cost principles and cost sharing requirements are assiduously adhered to. That all the little details of performing one of these awards that in a normal environment, staff at these agencies would be willing to work with recipients on, now are probably even under more of a microscope, to the extent that, folks are choosing to move forward with their awards at all. I will also say that there are certain organizations that are saying, this is not worth it. I don't need, basically to be fighting with my partner that is the government agency for the next 4 years. I don't need an unwilling dance partner, essentially. And this is just going to be more pain than it's worth. And they're making, there are board conversations happening about whether to terminate awards, unfortunately.
Noah, one follow-up to that question. What about awards where the state is the partner in that award? How are you seeing states react if the other half of the funding doesn't look to be coming through?
Well, they sued. So that's probably a good segue into Beth's piece of this. But I think a large number of the states have been pretty aggressive in court on that front, which is great to see. I will also say, hearing from a lot of friends down in Washington that even some of the red states are quietly, lobbying in Congress through their representatives for, some of this to be released, or at least for there to be a clearer definition of what the administration's policy is. So my sense is that states, they like money in their accounts, and they don't like to be hearing from a lot of constituents who are uncertain about whether they're going to be getting the benefits of those programs. So, I think the states are actually more, to a great extent, especially, obviously the more progressive energy states are in a sort of simpler position with respect to how to react than some private entities who are trying to figure out whether they want to deal with the headache, whether there's a path forward here, and or frankly, whether they want to make an enemy of this administration. So.
Thank you, Noah. I want to remind everyone, if you have questions, please put them in the Q&A, and we'll get to as many at the end of the session. Let's move on to Beth with lawsuits, including what we said with the state. We've also heard that in the farming industry, people who paid money out with the intention of getting it back for environmental improvements, that money is frozen through USDA. Are individuals and state governments suing? What are the lawsuits we're seeing on the horizon, and what do you think the impact will be?
Sure, thanks, Natasha. So there are a few broad lawsuits that have been filed, and we expect to see more targeted ones. So let me take those in turn. I'll start with the easy, I shouldn't say easier. I will start with the lawsuit that I think is less important for purposes of our discussion today, at least for the moment. We'll see how it develops. And that is a lawsuit filed by several different nonprofit organizations. These are coalitions of nonprofit organizations. So the National Council of Nonprofits, for example, is the lead plaintiff, sued OMB in the DDC. So that's the District of Columbia. That case, there is a TRO pending in that case, and it prohibits essentially, I will pull up the language here. It enjoins OMB from enforcing the OMB memorandum that you might all recall was issued on the evening of January 27th. So 1 week after Trump entered office, OMB issued a memorandum the following Monday evening saying, essentially funding across, it was somewhat ambiguous. It was like funding across the board is enjoined. It did in some sections tie that funding freeze directive to 7 underlying executive orders that Trump had issued during the course of his first week. One of those was the Unleashing American Energy EO with, of course, the Section 7 language that on its face purports to impound all funds appropriated as part of the IRA, the Inflation Reduction Act, and the IIJA, the Infrastructure Investment Jobs Act. So this first lawsuit, this was actually the very first one filed, sought to enjoin that OMB directive. There was initially an administrative stay put in place, and the very next day, the Trump administration rescinded that OMB memorandum. However, the plaintiffs in that case were able to demonstrate a number of instances in which, or evidence that, agencies were continuing to freeze federal funds pursuant to the OMB memo that, despite it having been officially rescinded. So the court in that case issued a TRO, a temporary restraining order, which is currently in place prohibiting OMB from enforcing that memo or anything, or that memo under any other name. I will say, though, somewhat, to me, frustratingly, the plaintiffs in that case doubled down on seeking to enjoin the OMB memorandum only. In other words, I think a lot of us had hoped, and we've seen something similar in the state's case, which I'll talk about it in a second, that we would see, after OMB rescinded the memo, that we would see an amendment to the complaint to broaden the scope, to challenge at least certain of Trump's underlying executive orders. They have declined to do that. So we'll see what happens there. But right now, that case only enjoins OMB. The nonprofit's motion for preliminary injunction is due today. So, and I believe the hearing on the PI motion, the preliminary injunction motion, is the 20th. So we'll see what happens there. The state's case, the following day after the nonprofits filed, it might have been the 2 days later, 22 states in the District of Columbia filed in the District of Rhode Island. Both of these cases are before democratically appointed judges. In that case, boy, there has been a lot of action. There was a TRO issued very quickly enjoining OMB and all federal agency and agency heads. It enjoined those folks from interfering with funding based on the OMB memorandum, including under any other name or title. and it seemingly affected all federal funding recipients, but this has been an uncertain thing throughout this. So there have been so many developments in that case just in the past week that we don't have time to go through them all. It's something that we have termed a good illustration of what we have termed the funding games. The problem is that essentially any wiggle room that is left the government, not surprisingly, the government under this administration is seeking to leverage to limit the impact of these court orders that are against it. So in that case, there has been some ambiguity in some of the orders about whether or not the order in the state's case applies only to the federal funding of the plaintiff states or more broadly. And there was also, as you all know, there were many instances in which, despite the TROs in these cases, federal funding was continuing to be suspended in many, many programs. So over the weekend, I mean, especially under the IRA and the IIJA, much remained frozen. So over the weekend, the states filed another motion to enforce the TRO. That was granted, and it was granted with very broad language. So now the judge in that case, this is again in the District of Rhode Island, has said, hey, I was clear before, let me be crystal clear now. I am prohibiting you, federal government, from freezing any federal funding pursuant to the OMB directive on which you initially sued, or any of Trump's underlying executive orders. And there are a number of directives in that TRO saying that all federal funding has to be restored. Again, based on this broad language, it would appear that that applies to the funding of all federal funding recipients, but we would not be at all surprised if they continue to construe it as applying only to the plaintiff states in that case. If they do that, of course, though, that could result in a sort of odd situation in which they would continue to freeze the federal funding of states that are not suing in that case, most of which are red states, and they would be required to release the funds to blue states. So that could be a little awkward, but again, we'll see where that goes. So there's a lot going on. We have seen some of the programs that had been frozen, such as the EPA's Solar for All program that was frozen all of last week until Friday morning. The funds were finally released Friday morning, but there's many others that we are hearing remain suspended. So we will see what happens in the aftermath of this motion to enforce and the unequivocal language that we received from that court 2 days ago. But again, what the courts are saying is one thing, what this administration does may be another. So let me pause there. There's more to talk about there, and I could talk about it all day, but let me pause there to see, Natasha, if you have follow-up questions or if there's any questions about these particular lawsuits.
Noah, did you have something to add to that?
Oh, not before you go. I was just taking myself off mute in preparation for your next.
Okay. Before we go forward, Joe, I wanted to throw out to you that while all this is happening and we're seeing the effect of funding, are we also seeing the erosion of public support for these initiatives for clean energy and climate technology? What are we seeing in the market? Do you feel like, in spite of all this, the market is still robust and people still want to move forward?
Well, there's a couple of things. I think, as you know, Natasha, because we've launched the nation's first ever misinformation tracker, there was a direct lead throughout this campaign over the last couple of years, a direct attack on the efficacy of climate technology. And no longer you see those forces attacking so much the legitimacy of the climate crisis, but sort of putting out false narratives about whether wind farms create environmental hazards or kill whales or so forth. But where the erosion is happening now is around, and I think Noah touched on about this, when there's uncertainty in the markets, investment steps back, right? Projects, that's what causes delay. I've said this publicly and over many interviews, is the undercurrent of momentum of the clean energy transition cannot be halted. However, there are going to be slowdowns around different aspects of that transition. I did a lot of study in my career, throughout my educational career, of presidential history and powers. The president has certain executive powers, some, not as many legislative, but one of the greatest powers any president has is the rhetorical power. When they say something, when Air Force One lands, it sends a very direct message. So uh, obviously, the direct result is executive orders are having a chilling effect on investment, and there's no mention on projects. People are saying, "Do I even want to go to business with the federal government? Does the full faith and credit of the national government have any worth to us anymore? Can you trust them now or down on the road? Is the rug going to be pulled out from under us?" But also, when you hear, what is affecting us in this industry is this all the talk and action around tariffs. Was on a panel about a month ago for State House News in the Commonwealth of Massachusetts in Boston. I sat next to the new chair of the Republican Party from Massachusetts. She had said, well, that's just Trump's way of negotiating, put out these threats and do things to get what he wants. Yeah, but the effect is immeasurable in many cases. It certainly raises antennas, and we've seen some of those threats become realized through executive action or actions on tariffs. So I I don't know where that's happened. I'd submit, that's not having as much of an effect on the general public as much as what if and when any of this funding gets pulled and their projects don't happen, what that means locally. And I speak specifically to, as an example, manufacturing under the IRA. There's a Utah state study that came out a couple of days ago, which pointed that, Trump's attempted rollback of the IRA is going to have a greater negative impact, a profound negative impact in Republican-held congressional districts. I think the figure was like 80% of those manufacturing investments in the IRA went to Republican-held congressional districts, and about $10 billion. And that's why one of the hopeful things is that, because I don't expect any profiles and courage of direct advocacy, public advocacy against the administration, but the Republican legislators are working behind the scenes to advocate that those projects move forward because they mean positive impact on jobs and revenue to those districts and affiliated industries like metal and steel fabrication and shipbuilding and many other things. So I think confidence, their attack on public confidence to erode public confidence was on the efficacy of climate technology, almost as a basis and foundation to take the really draconian actions they're taking now. Right now, it's investor confidence, right? And uncertainty. Do you trust, no matter, to go into business with the federal government? Is there full faith and credit? Does that mean anything to you? And can you do a deal? Will those deals hold up? Will they transcend administrations?
Thank you, Joe. So we're talking a lot about funding. I wanted Noah to take this question. Obviously, what the Biden administration did is sort of combined good policy with funding. What is the potential for federal funding moving forward, do you think?
Um, Let me get my crystal ball. You hear a lot of conjecture around all of this. Some people say this is the end. They're going to kill the ITC and the entire economy is going to crater. Some people say, oh, well, they couldn't possibly, take adverse action against the red states because why would they do that? And some people say this is just a lot of bluster and we'll get back to equilibrium in 6 months and everybody should just sort of, be patient and hold their cards to their chest for the time being. I don't know that any of those is correct, and I don't think anybody really has any idea how this is going to play out. So in terms of continued funding from the federal government, I think, frankly, for wind, onshore and offshore, that's probably, and by funding, I don't just mean direct financial assistance, but also, appropriations for staff to, work on these projects for permitting and other things. That's probably dubious, I would say, because the administration has just taken a position and it's going to be hard for them in any reasonable period of time to soften that. But there are bright spots, right? I mean, I think Geothermal, for example, will likely continue to be supported, both large scale and smaller scale. Um, I'm hoping that transmission programs will continue to move forward. Those are obviously important to the renewables industry, but frankly important to utilities and anybody else who is trying to move electrons around the country. Um, I would expect that, distributed solar, for example, doesn't have, other than the tax credit, which is a big caveat, but other than the tax credit, there's not a lot of federal interaction for 5 megawatt solar projects, um, and one would expect that over time that will continue to sort of move forward, not without hiccups and uncertainty at the moment, certainly, but I would hope that those projects would continue to be able to move forward. So, I don't know that the sort of the programs like the Office of Clean Energy Demonstrations or the Office of Greenhouse Gas Reduction Fund or some of the more high profile programs under the IRA and BIL, IIJA are going to continue to move forward. I think that they won't. It will be in this, I was general counsel of NYSERDA back in 2016 when we went through this the last time. And New York really led the way in terms of stepping up to fill the gap of federal inaction. We formed the United States Climate Alliance with a range of other states, and ramped up state incentives and programs to try to fill the missing money gaps for a lot of projects that were uncertain whether there was going to be continuing federal support. I mean, the states have to do that again. And it's hard because, frankly, the missing money is bigger than it used to be because we're now into deployment and implementation of these projects, large multi-billion-dollar projects, not just sort of the program planning and the setting up of all the infrastructure and regulatory systems to support them. But if these sectors of the economy that are dependent on federal funding are going to, continue at a pace that will sustain them through these 4 years, the states are going to have to pick up a bunch of slack. And I hope that there's the political will to do that. It's not a small ask. I also think that there's a good deal of private money out there that can help. There's a lot of philanthropy. There are a lot of large funds, both in the United States and around the world, who are looking for places to put their cash. And the effort to ensure that this market and its investability, if you will, is not injured to the extent that those funding sources decide to go elsewhere, should be a high priority for the states over the course of the next 6 months, because people are watching around the world. And, to the extent that the private sector cash remains in place, that will only reduce the cost to the states of meeting the important targets that they've set themselves. So, I mean, there's still money out there, but this is definitely putting the question of how it all fits together into a bit of a washing machine for a period of time.
Beth?
Yeah, so I think that something that Noah just said at the end there is key in terms of putting this into a washing machine for some period of time, because I think I wanted to return to the lawsuits, not so much the procedural morass that I was talking about before, but rather the legality of these actions on the part of the Trump administration, because I think we would be remiss to not at least briefly discuss today the illegality of what is happening here. So we are hopeful that ultimately, as we've already seen in these lawsuits, the states and other plaintiffs here who are fighting for their funding will prevail. And I will talk about that a bit more. But the problem is what is going to happen in the meantime. The problem and a lot of questions remain about the administration's compliance with any relevant court orders, whether during the pendency of the litigation, such as with a temporary restraining order, a preliminary injunction, and then the final injunction that comes out of it, any final form of relief. But you are seeing these TROs issued in these cases because of the fact that the plaintiffs can demonstrate a likelihood of success on the merits, as well as irreparable harm. So what does that mean? Irreparable harm means just what it sounds like, harm that cannot be fixed later on through a damages order, right? So as you are all well aware, when it comes to a lot of these organizations, even if they were ultimately granted damages months or years down the road after litigating this to fruition, that doesn't mean it would fix all the harms that it is causing right now. A lot of people, a lot of organizations, a lot of states, municipalities, individuals, organizations are hurting because of this funding freeze, unable to pay workers' salaries, unable to move forward with critical projects, etc. And then on the merits question, in other words, who's right on the law? There's no real question that Trump's his efforts to impound these funds are unlawful. So what does that mean? Impoundment is a term used when an executive seeks to rescind or not spend congressionally appropriated funds. And that includes merely a suspension. It's not just about permanent rescission. There is, we have a long history of precedent in this country going back to the 19th century with the Supreme Court saying, no, Congress has the power of the purse, not the executive. And the notion that the executive can impound congressionally authorized funding under the Take Care Clause is, I think the words used were something like, is a novel interpretation of the Constitution and one that cannot be admitted. Because if the executive can say, I'm refusing to spend these funds pursuant to my prerogative and really my duty to take care that the laws are faithfully executed, the president would in fact be in many respects changing those laws that Congress enacted. This was reiterated during the Nixon era because Nixon sought to impound funds repeatedly. Even President Reagan's own Office of Legal Policy at the DOJ reiterated this, saying that the president has no authority to do this. As many of you who have been tracking this probably know, under Nixon in 1974, Congress enacted something called the Impoundment Control Act, which does provide a narrow pathway through which a president can seek to impound funds. Again, that means to refuse to spend, period, or to suspend them. But in a nutshell, it always requires the authorization of Congress, the body that has the power of the purse. Not surprisingly, Trump has not sought to use that path. In fact, he and his pick to lead OMB, Russell Vought, have repeatedly said that they think that the ICA, Impoundment Control Act, is unconstitutional. Instead, he says, I have inherent authority to do this. His theory for that is the one that has been repeatedly rejected over time. So where do we think this is going? I would be, even with today's Supreme Court, shocked if the court were to sanction a president's authority to impound obligated funds, right? And that is a lot of what we're talking about here. If that were the case, then federal contracts would no longer be worth the paper they're written on. So I think that's clear. What's going to happen until we finally get that pronouncement? It's going to be a mess. The closer question on whether for the first time a court, and the Supreme Court in particular, would permit the impoundment of congressionally authorized funds. Honestly, I'm still dubious, but this court has shown obviously a willingness to overturn long-established precedent and a very expansive view of presidential power. So I am hopeful that that will be denied as well under basic separation of powers principles, but that I think is less certain. But I do just want to emphasize that what we're talking about with these impoundments is the freezing of a lot of obligated funds. In other words, funds that have been awarded under binding contracts. And no one has ever before sought to impound obligated funds, and I would be shocked if any court would permit it. Okay, with the exception of perhaps some portion of the Fifth Circuit, but thankfully that's not the Supreme Court. So more to come there, but I wanted to make clear that these are lawless actions. There's also, by the way, you could try to root this. There could be in the statute themselves. It's conceivable that Congress could have enacted the IRA and granted within the IRA a good deal of discretion for the president to do something like this. That is not the case. Trump has not sought to tie his actions to any of the statutory language in any of the authorizing, any of the legislation that authorized these funds. So I think little question that these actions are unconstitutional, ultra vires under the authorizing statutes and the Impoundment Control Act, and in many respects violate the Administrative Procedure Act because of arbitrary and capricious agency action, ultra vires agency action, et cetera. So pick your cause of action. There are a lot of them. But again, that doesn't necessarily mean that we will see compliance with court orders from an administration that has already shown itself very willing to defy the law in many respects. So.
Thank you, Beth. And I could listen to you three forever, but we have some really great questions I want to get to. And since you're talking about lawsuits, Beth, and I know this has been on my mind, certainly DEI and environmental justice. The question we have is, what about a small place-based environmental justice organization who receive federal funds? Should they wait? Should they join a lawsuit? How do they find a voice if they're a small nonprofit organization?
And Natasha, this is specifically with respect to the impacts of the DEI orders. Is that the question?
No, it's they receive federal funding. They're an environmental justice organization, and it doesn't say whether it's frozen, but we'll assume that the money is not coming in. Do they just wait to see what happens, or should they join a lawsuit? And again, it's a big difference from a corporation to a small nonprofit. How can they operate during this time?
Sure. So let me answer that to the extent I can. There's a lot of unknowns there specific to this organization. And this is true. Like when you're talking about any entity, so much of this is organization specific in terms of the calculus. But number one, something that Noah and I have been counseling clients on now for some time, but it's especially urgent now, is understanding the terms and conditions of your award. If they have federal funding in place and open awards, it is imperative that folks who are recipients of federal funding take a very close look at their awards so they understand their obligations. In other words, like as Noah was speaking about earlier, you don't want to give them any wiggle room to accuse you of failing to comply with your milestones, with your other obligations under your award. But you also need to know your rights. In other words, on what basis does the agency have the authority to terminate the award or unilaterally modify or amend the award? Again, that doesn't mean the agency will act consistent with that, but you need to know what are your rights and obligations under your award, number one. Then the question I do think is somewhat, is the funding frozen? Let's assume that it is right now. Number one, I already said number one, so let me stick with that one. What you need, I think, coming in the next few weeks is monitoring what happens with a lot of these awards that still remain frozen in light of the TROs that are in place, and especially in the state's case, where there's broad language that suggests a nationwide injunction with a scope in no uncertain terms. In other words, that TRO now says you must stop freezing funding, reinstate funding that was frozen on the basis of any OMB memorandum, any of the president's executive orders, et cetera. So again, we're hopeful that we will see more of that. We're not entirely confident of it. So I would say, take a close look at your T's and C's, monitor the lawsuits to see what is happening. But then, yes, you should be planning for a responsive strategy if push comes to shove and you need to assert your right to protect your own rights, right? You cannot necessarily rely on the lawsuits that others have filed because of the fact that it may not be applied to you. This gets into a tricky area on sort of the the efficacy and uncertainty and skepticism on the part of multiple Supreme Court justices about nationwide injunctions. In other words, about whether you can avail yourself of the relief, whether you should be awarded that relief, even though you are not a plaintiff in the case. So I certainly think that folks should be starting to think about, what are we going to do if we need to assert our rights?
Yeah.
I think for some organizations, this means looking for funding to support that, possibly working with other organizations who are similarly situated. Sorry, go ahead, Noah.
No, sorry, I didn't mean to interrupt. One thing that I'd say is you should be in touch with the National Council on Nonprofits, who is a plaintiff in the lawsuit down in the DC District Court, to find out what resources they're providing to their membership or to other nonprofits who are wanting to understand how to navigate through this, and also, to consider participation in that lawsuit. There are ways to participate in lawsuits where you're not necessarily a party. You can file amicus briefs. There are lawyers out there who are being funded by third parties to help, to help nonprofits who can't pay for their own legal counsel. There are lawyers who are doing some of this work nonprofit pro bono. So there are opportunities out there for support. But I would probably start with the National Council, who's sort of leading the charge for the nonprofits in the lawsuit right now.
Thank you both. We have a bunch more questions, and each one probably could be its own webinar, but I'm going to try to ask folks to answer them as quickly as possible. I know that's really hard, so we can get through as many of these as we can. This one for Noah, possibly. What is your analysis of the direct pay provision for the ITC, and what are the risks and steps entities hoping to use the direct pay should be considering?
Right. So this is a little distinct from the sort of funding freeze conversation that we've been having so far, but an important question. I think everybody was somewhat relieved to see that neither of the sort of energy-focused executive orders expressly addressed the tax credits that are authorized for and appropriated under the IRA. So that's good, right? They weren't sort of first in the line of fire. However, there are broad statements in the Unleashing American Energy executive order that require all agencies to review rulemakings and make recommendations with respect to those rulemakings that were done under the IRA or an IIJA for consistency with the policies as stated in Section 2 of that EO. So that's a very broad sort of drive a truck through it, send all the agencies out there to essentially, figure out whether the policies are consistent with the IRA, with the president's policies currently. The other playing field, obviously, for the tax credits is in the reconciliation and budget negotiation process on Capitol Hill. And what I will say is that, this is the time to engage in that conversation. This is not a drill. My understanding is that the House Republicans' first proposal in that respect will repeal all IRA tax credits. Adders, continuations of the base ITC, that's coming from intelligence from people who are walking the halls in Washington as recently as yesterday. So, if you know a lobbyist, if you are a lobbyist, you should be making sure that your story is being told in Washington like yesterday. Because I think that these tax credits are going to be a football as part of the reconciliation and budget process that's going to be taking place over the course of the spring and summer on Capitol Hill. Unfortunately, I mean, the other risk to this is notwithstanding legislation, as we've seen, and I don't mean to scare people, but I want to make sure that we're not gilding any lilies either, because I do think that if I give these folks credit for anything, it's that they are creative. They keep on doing things that, frankly, people didn't expect. So one tactic may be, let's issue a notice of proposed rulemaking at Treasury and IRS to essentially change all the good stuff that had been implemented over the course of the last couple of years under the IRA to the sort of mirror image of less advantageous or less certain, and they could do that and push the envelope, maybe even ways that was arguably outside the scope of the authorizing legislation. And all that does is throw a lot of sand in the gears and make people sue them and create uncertainty, which is what they're shooting for. So, I think that there's risk to those tax credits. And Natasha, I didn't keep it short, sorry. But this is it is not the case that just because the executive orders didn't mention those tax credits expressly that I think that they're sort of out of the woods.
Yeah, we have another question along that line, which is anything is possible. Could the feds also try to block local climate initiatives like Brado, LL97, Bruto?
That will depend on, to some extent, on, whether or not there are any federal approvals required. So, for example, congestion pricing in New York City has been, I think there's process ongoing where EPA may essentially withhold its approval of that and scale it back. So, that will be a sort of program by program question based on whether or not there are any federal authorizations required, and or whether there is sufficient authority in state law to move forward with it sort of standing alone. So I don't know if I can answer the question specifically, but from a legal point of view, I think the question is whether there's a touchstone at the federal level.
I'm going to give this one to Beth. So what principles honoring contracts and agreements should be proposed by the U.S. Climate Alliance or nonprofits? Is there a framework coming out of these lawsuits? That's a really big question. Um, but is there a framework coming out of the lawsuits that needs to be pushed forward?
Boy, maybe I would need to give that some more thought. I would say that a good place to start would be honoring contracts, which, I think we had all thought maybe we were on the same page about before, but this administration is certainly pushing the envelope there as well. So I think that for further comment on that, I'm going to keep my powder dry, if you will, and see how these lawsuits progress. But Noah came off mute, so I'm hoping he is.
I'm just gonna go a little bit farther than Beth did. One thing that Beth noted, which is really important and seems to get lost in the sort of ether sometimes, is that there are really sort of two universes of funding at issue here. One is funding that has been authorized and appropriated by Congress, but not yet obligated under a contract, right? That's usually what people are fighting about. That's usually like, oh, well, the contract hasn't been signed yet. The government still has some discretion, either Congress or president, and they can fight about who it is to, redirect that funding. What we're dealing with now is a bunch of money, probably trillions of dollars, that are actually already under contract. That is a whole other world of, obligation, to use a technical term, and legal sort of analysis that I think doesn't get enough attention. That is the distinction between those two buckets of money. And so what I'd like to see is more emphasis on exactly what the premise of the question is, which is, as Joe mentioned, what is the full faith and credit of the United States government once they actually sign a contract? Are we an investable economy or not? Because the legal issues are important there, but the sort of economy-wide issues, I think, are extraordinary and probably not kind of seeping into people's minds as a question that is actually being posed at the moment.
Thank you. We are at time. And I apologize for going over a couple minutes. I just want to give each speaker a quick final word. And also, Noah, we have someone who wants to know why you're so positive about geothermal, and maybe you can throw that into your closing remark about why geothermal has an opportunity. And I also want to let our panelists know that we are going to be doing this again in a couple of months because changes are going to continue to happen. Secretaries are going to get appointed. Agencies may or may not close. Different branches may or not close. And we want to make sure that everyone continues to be updated as this goes on. So please look for more events on our LinkedIn. You can also go to our website um, and sign up for um, uh, becoming a member or join our Activate network to get real live updates and make sure you hear about the events that are happening in our organization. And I'll give everybody a minute, and then I know people have meetings back to back during these crazy times, and let everyone go. Beth, you want to start?
Sure. I will just start by continuing, I think, with a bit of the message that Joe discussed at the top of the hour, which I really appreciated, and that is, I think, a message of hope, which is hard right now. But what I have to remind myself of some days is that what they are going for is, to completely overwhelm us and discourage us. And a lot of what we're fighting for here, and a lot of what you all are part of trying to create, is worth fighting for. And we have to continue every day doing what we can and resisting during this time. So some of that is just the basic steps of learning your awards, right? So you're prepared to defend them as well as you can. Others are preparing for litigation if that is something you can do, and others are continuing to make your workplaces inclusive communities for everyone. There's so much that we can do, but it is important to continue, because otherwise they win. So I guess that's what I think is an important note to end on.
Thank you, Noah.
I'll be super quick. First is thank you all. It's a pleasure to be here. Is really, Beth and I will now go back to our very full inboxes to deal with like the day-to-day scrum, but it's important to pull back every once in a while and think about the bigger picture. And this was a good opportunity to do that. In addition to all of our work on behalf of our many clients in this predicament, we also are trying to put out, writings every once in a while, blog posts. You can check out that on our webpage, Foley Hoag Energy and Climate Council. Beth and I and some of our awesome associates have one called Impoundment by Any Other Name. So if you want to actually read all of Beth's brilliance with respect to the legal analysis, you can do it there. And we've probably got another one coming out soon. It's just every time we write one of these things, it's like gets overcome by events. So that's all I'll say. Thank you again to Natasha and Joe and everybody else at ACT for the invitation.
Thank you, Noah. Joe?
Yeah, I'll be brief and just build upon those final comments. And thank you to Beth and Noah and everyone for joining us. As has been said, don't let them grind us down. What we're fighting for is greater than whatever they're trying to reverse exponentially. Let's not let the lie become the truth. We need to fight misinformation. But, advocacy is going to be important, and that comes in many ways. To be public about that, but you could start by calling not just your own federal delegation, work through the organizations that you're aligned with, either regionally or nationally, to call other delegations. That has an effect, a positive effect. People need to hear voices, and it's important that we continue to amplify, again, the voices we talked about earlier, alluded to, but also the positive economic impacts we're fighting for. And we're fighting for people, place, and planet. So we're going to go through a bumpy patch here, but we're going to persevere if we stick to our values, be aligned by those values, and continue to build and strengthen coalitions.
Thank you so much. Thank you to our panelists. As I said, we are going to look at doing another one of these in a couple of months as changes quickly happen. Keep you informed. Sign up for our newsletter to get the latest events, and you can join us. And also, as Joe said, um, while not only is there a funding battle going on, but there is a public relations battle going on as well around um, climate change, climate tech, clean energy, and its effectiveness. And we need to get everyone on the same page now. Thank you so much for joining us today, and have a wonderful rest of your afternoon.